So good morning, everyone. My name is Hugo Romero, and on behalf of President Ron Herrera and the LA County Federation of Labor, welcome to this webinar as part of our continued When the Paycheck Stops series with Labor and Community Services and its Executive Director, Armando Olivas. Today, we're joined by Ford and Wallach. Of course, Scott and Cheryl are on with us to talk about workers' compensation during COVID-19. I'm going to kick it off to the Executive Director of Labor and Community Services, Armando Olivas, who will be giving us an overview of the great work LCS has been doing.
Well, thank you. Thank you. Good morning, everyone, and thank you for joining us. I want to just say a special thank you to Hugo. He has done a remarkable job carrying the torch for Labor Community Services on the webinars on how to survive when the paycheck stops, and some very, very useful information, as you will see today, that Hugo has put together. So I was scheduled to teach at LA Trade Tech College last April, and it's the series of how to survive when the paycheck stops until the pandemic hit. But I know we will return. We will go back to teaching classes. I teach the labor and disaster class, and again, how to survive when the paycheck stops. So look forward to that soon. It will be coming your way. So just to recap, Labor Community Services in the past 7 weeks have been able to, with the help of staff from the LA County Fed, the Miguel Contreras Foundation, and many volunteers, including yourselves, we were able to feed over 40,000 families in 7 weeks. That's around 160,000 individuals. And we couldn't have done it with the help of LA Regional Food Bank. They've been a tremendous help to us. And we will continue to feed families in need. We regionally are moving it around. We purposely did that to make sure each corner of our county receives food. Our next ones, it'll be Thursday, May 28th at Wilmington, the Ports Drivers. And on May 29th, Friday, May 29th, we'll be in Sylmar with the Hollywood Craft Unions, the IAs, SAG-AFTRA. Saturday, May 30th, we'll be back in Pico Union area, really hard hit area. And so we are going to provide food to around 2,000 families in the Pico Union area out of the LA County Federation of Labor. If you're available, you can go on our site and you can sign up to be part of that. Or if you want more information, look at lcs-la.org. Again, thank you. You have a very, very professional panel today, and I'm pleased to be part of this. Thank you for all your support and help to Labor Community Services. Thank you.
Thank you, Armando. And yeah, the work LCSLA has been doing is really tremendous, and thousands and thousands of families across LA County have benefited from the work of Armando and the team that have really risked their own health to be out there providing food to folks. So thank you, Armando. And just another thank you for folks to Scarlett Ying, our comms associate at the Fed as well, for great work on these webinars. So now to kick off to the main presentation, I know a lot of you are logged on today for Scott and Cheryl of Ford and Wallach, who will be giving a very informative presentation today. And just in terms of format, as we can imagine, we know there's probably lots and lots of questions. Feel free to type them out on the chat, but do please know that for the purpose of protecting your privacy and strictly for that, there are many questions, if they are very individualized, that Scott and Cheryl will not be able to answer. As the host, Scarlett and I will try to answer and follow up on generic and general questions that maybe clarification could be provided for. But for very individualized and case-by-case scenarios, for just protecting your privacy, they won't be able to answer them. Bear that in mind as you pose questions in the chat that you might want answered. So without further ado, please, thank you so much, Scott and Cheryl, again, for being here with us today. Please take it away.
Thank you very much. It's a pleasure to be here today. Can we go to the first slide? Actually, I think we're back up one, Jason. There we go. Okay, so just a little brief description of Cheryl and myself. We want to let you know that we're both certified by the State Bar as specialists in workers' compensation law. We've both been named super lawyers by Los Angeles Magazine and Law and Politics Magazine, which is a poll amongst lawyers as to who the best in the profession are, a poll by lawyers themselves. We both are members of the board of directors of the California Applicants Attorneys Association, which is a group that lobbies for bills in Sacramento that favor injured workers. And finally, we both teach at LA Trade Tech College. We teach workers' compensation and employee benefit law. I've been on the faculty there for about 25 years. I've also been practicing with Cheryl as my law partner for about 25 years. We tell you about ourselves, not that we want to so much give you our resume, but we want to convey to you that this is what we do. Like I said, we're certified by the State Bar as specialists in this area, and 24/7, we eat and sleep workers' compensation. So, did you want to add anything to that, Cheryl?
No, I just wanted to thank you for the opportunity. We're happy to be a resource to anybody who has any questions. And Scott and I are true believers in the workers' compensation system. And like Scott said, we eat, breathe, and sleep workers' compensation.
Sure. And we're also members of AFT 1521 as instructors at Trade Tech. So can we go to the next slide, Jason? So let's get started. This is what this whole seminar is about. If a person is at work and they get COVID-19 or coronavirus, they have a right to file a workers' compensation claim. Let's make that plain, clear, and simple. If you get the coronavirus through your work, you absolutely have a right to file a workers' compensation claim. As lawyers, we use the expression AOE-COE, and what's that short for is arising out of the employment in the course of the employment. So as a lawyer, I go to court and I talk to the judge, and the judge will say, hey, Scott, is this case AOE-COE? And what he's really saying is, did this case arise out of employment in the course of employment? Or in other words, is this a work-related case? And yes, the answer is, if you get the coronavirus through your work, it is an AOE-COE. It arises out of the employment in the course of the employment. As a matter of fact, early on in this pandemic, our insurance commissioner, Ricardo Lara, issued a proclamation indicating that anybody who is infected with COVID-19 through the workplace has a workers' compensation claim. And that includes anyone who's undocumented, and it may also include people who previously weren't eligible to file claims, people who were previously gig workers who may be considered employees at this time. So let's talk about that. Everybody who gets the virus at work has a right to file a workers' compensation claim. But with that said, not every claim is worth pursuing. Not everybody needs to file a claim. 80% of the people we understand who get this virus are going to make full recoveries. They're going to have mild symptoms. They're going to get back to work. They're going to get back to 100%. I mean, we hope it's 100%. But for those 80% who get better, there really is nothing worth pursuing. There won't be any benefits. You'll get better. You won't want to go through the time and the delays of filing a workers' compensation claim. Like I said, that's about 80% of people who get it. Unfortunately, not everyone is that lucky. The other 20%, we know the symptoms can be much more severe. As a matter of fact, Cheryl and I are already representing a lot of people who've gotten the COVID-19 through their work experience. We have, unfortunately, clients who are on ventilators, coma, hospitalized, and very unfortunately, we represent several families of people who've died on the job as a result of getting the COVID-19. So for those people who don't make 100% recovery, it's an important thing that we understand what their workers' compensation rights are, and it's important for us in the labor community to advise the people around us to understand what's important and what the laws are and what their rights are. Can we go to the next slide? So again, the big issue we want to talk about is causation. Causation is the most important issue, and I use those terms before, AOE-COE. Did it arise out of employment in the course of employment? Because the coronavirus is different than the flu and the common cold. And as a matter of fact, the flu and the common cold are not considered to be workers' compensation claims. So why is that? Well, in part because the flu and the common cold you're going to get better from. They're also so widespread, it's very hard, if not impossible, to say if you got the cold at work or if you got the cold at home. But that's not the coronavirus. The coronavirus has already been determined to be a pandemic by the World Health Organization. It's got an extraordinarily high contagion rate, which means it's very easy to pass. And employers can take all the precautions in the world and still, unfortunately, not be able to spread the risk at work. So how do we prove, causation again, how do we prove that work caused you to get the virus? Well, we put it in caps here. Workers have to show an increased risk compared to the general public. That's the law in this area. The case law indicates that in order to show that you have coronavirus and that you contracted it from work, you do not have to show with medical certainty. You do not have to show with preciseness. You do not have to show exactly actually that you got it from work. What you have to show to meet your burden under the law is that the job that you were doing gave you an increased risk compared to the general public. So in other words, whatever I'm doing for work, I had a greater risk of getting the virus than the general public would. The general public either at home or somebody working in a different job. It's my personal opinion that anybody who is currently working during a time that the governor has a stay-at-home order, during the time that the mayor has a stay-at-home order, that by virtue of the fact that you are working, you obviously have an increased risk compared to the general public, to someone who's ordered to stay at home. With that said, I mentioned Cheryl and I are on the board of directors of the California Applicants Attorneys Association, and we're working with a coalition of unions on a legal presumption in favor of workers. What is a legal presumption? A legal presumption allows the court or a judge to accept something as a fact without further evidence. So in this case, we would say, I had an increased risk compared to the general public. The court should accept the fact that I'm working as the fact that I contracted the virus at work without further evidence. And that's called a presumption, a legal presumption under the law. And legal presumptions are very important because many states across the country have enacted legal presumptions in favor of workers. So if you have a legal presumption in your favor, it means that it is easier to bring a case forward. Can we go to the next slide, Jason? So, effective May 6th, our Governor Gavin Newsom issued an executive order N6220. And what he basically indicated in that order was that there would be a rebuttable legal presumption for workers. The presumption is that anybody who is working between the dates of March 19th through July 5th, 2020, who has the virus and is working or was working, would be presumed under the law to have received the virus through work. Now we call that a rebuttable presumption because it's not absolute. It means that the injured worker, by working and getting the virus, already makes their case under the law. But it does allow the employer to rebut that, the employer or the insurance company to rebut that with other evidence. Again, this order is good basically for 107 days. It takes place retroactively from March 19th and applies towards July 5th, and that's it. It's limited in its nature. Can we go to the next slide, Jason? So I think it's important for us to talk about presumptions. Again, Governor Newsom gave us an executive order which indicated that there be a rebuttable presumption. A rebuttable presumption allows the person who's making the claim to have a finding in their favor, but that finding can be challenged with additional evidence. That's different than a conclusive presumption. Under the law, when we have conclusive presumptions, it means that the other side, in this case it would be the employer, if we're representing the injured worker, would have no grounds to challenge the finding of a work-related injury. They could challenge the nature and extent of the injury, but they couldn't challenge what we called earlier the AOEC. They couldn't challenge the fact that it arose out of employment in the course of employment. So when the legislature adopts a conclusive presumption, it's a finding in favor of the worker that the injury was absolutely work-related. And then there's the third type of presumption, which I call the common sense presumption. It's not necessarily a legal presumption, but under the law, it's our argument that anybody who looks at this set of facts has to come to the following conclusion. And as I mentioned before, as far as I'm concerned, if there's a stay-at-home order from the governor, if there's a safer-at-home order from our mayor, and if you're working as an essential worker during this period while other people are at home, I believe common sense will dictate that a judge must find in favor of the injured worker to show, one, that they were at increased risk of getting the virus at work, and two, obviously that the virus was a work-related injury.
Can I add something? Can I add
Sure.
something, Scott? Just so you are aware also regarding these presumptions, as time goes on and whether or not we have a stay-at-home order or not, these presumptions are going to be more and more important. So that's why we're working on trying to get the presumption and hopefully a conclusive presumption. But that's going to be more important as the facts change in regards to the stay-at-home order from either the governor or the mayor.
Thank you. So the next slide, back to Governor Newsom's order. So we took a minute describing what presumptions are. Newsom issued an executive order, again effective May 6th, with a rebuttable presumption in favor of workers. So why did I spend a minute or two talking about presumptions? Well, for a couple of reasons. The first is that Newsom's order is limited in time. It's only valid for 107 days. I've already been told that many insurance companies and employers may be challenging the presumption, may be challenging his executive authority as to whether or not he had the power to do so. Workers' compensation benefits are written into the California Constitution, and there is some legal argument out there that the governor does not have the right to sign an executive order regarding a presumption. And this presumption, as short in nature as it is not going to affect people when they return to work after July 5th, 2020. So the reason we want to educate you on presumptions is because the California legislature is in session, and they're going to be in session until August 31st. And it's our hope that the legislature will actually pass some laws or some statutes, one, creating a rebuttable presumption, or two, even better, creating a conclusive presumption. There's actually 3 bills up in the legislature right now, one by Gonzalez, one by Cooper, and one by Hill. All of these bills deal with some type of presumption in favor of workers who contract the virus at work. One is a conclusive presumption, the other is a rebuttable presumption, and the third bill, I think, is somewhat of a spot bill, and we don't have more information. But we all should understand this idea of presumptions because it's going to affect the people that are working and the people that we are representing. Can we go to the next slide?
So now the question is, what do we do in regards to proving we have a workers' compensation claim? Many of you would recall back on March 19th, you think you would remember that day clearly because that's when the executive order from Gavin Newsom came in saying that we had the stay-at-home order. However, as time goes by, even now, that day is becoming more and more blurry or less clear in regards to how you were feeling, the facts that were surrounding it. Well, the same thing is going to apply here in filing the workers' compensation claim and proving that you have a workers' compensation claim that arose out of the employment and during the course of employment. We have to prove to a judge, and we won't be able to go to a judge for maybe a year to 2 years before we can prove all of the benefits that the injured worker is entitled to. So what we need to do is we need documentation. Why do we need documentation? We need it because we need to prove it, and that's going to be the best evidence that we can use. How do we document? We can document by diaries, we can document by emails, and we can document by medical reports. So between the who and the how, that's where it becomes very important. The injured worker can document by keeping a diary in regards to who contracted the virus first in your household, who was the one that was going to the market or running other errands versus who was actually just going to work and coming home. The insurance company or the employer is going to try to prove, and depending again on the presumption that we have, that either the virus was contracted outside of work or that you got it from a family member or someone else. So having the documentation as far as other people at work who contracted the virus as well, showing that you were the one that got it at work versus you were the one that got it at home and brought it to work. Any of those facts, and keeping a diary or a log. Who else can document? The doctor. The doctor is the one who's going to document the symptoms that the injured worker has. Who else in the family has the virus? Who was the first in the family or at the home to contract the virus? And what other symptoms that person's going to have besides coughing or respiratory problems. The doctor's medical reports are going to be used as evidence that we show a judge. Finally, the most important thing that we can show is documentation from a union. And you as union leaders can keep track of complaints. Did you send an email to the management in regards to how they were keeping the workers safe? Were they providing masks? Were they having meetings and not having social distance? Any of the information that you have as a leader or as a steward that can show that there's letters where the employer wrote saying that other people have contracted the virus and now we need to stay at home. Anything that we can use to tie the fact that a person is diagnosed with COVID-19 and now has it because of work. Did you want to add anything, Scott?
Yeah, I would just say, as lawyers, we have to deal with evidence. And again, when we represent somebody, whether there's a presumption or not, we make an argument that they were a greater risk than the general public, that they contracted the virus at work. But then the burden shifts to the employer, and the employer often will argue, no, you didn't get it at work. And what Cheryl's talking about is the evidence that we need. When we go to court and we represent our people, we want to show, look, here's other people on the job who got the virus at the same time. Here's what the doctor said when they initially saw the injured worker. Here's what the union took notes on to show that there was a spread in the workplace. And the more evidence we have, obviously, the better job we do for each other.
Next slide, Jason. Medical treatment. Medical treatment is the most important benefit under workers' compensation. The first thing that you need to do if you contract the virus is to go get treatment. As you know, under the regular law, an employer has 90 days to investigate a claim to determine if the injury, or in this case, the virus, is work-related, or as we discussed, arose out of the employment and during the course of employment. Gavin Newsom's executive order does change that time limit to 30 days. And as Scott mentioned in the past slide, we don't know if this is going to be a valid executive order or not. Whether it's 30 days to investigate the claim or 90 days to investigate the claim, if a person waits for the employer or insurance company to provide treatment, they could either be on a respirator or dead by that time. So what we are telling people to do is to go ahead and get treatment as quickly as possible through their own means, either through their health insurance, and get the treatment that they need. The time limit to file a workers' compensation claim is 1 year. We call that the statute of limitations. That means that a person who contracts the virus does not have to file a workers' compensation claim and fill out a claim form until they have up to 1 year to file that claim. The time limit is 1 year from the two things: the date of knowledge that you have an injury, meaning that you've been diagnosed with the virus, and the time limit also is from when you know that it's work-related. What does that mean? That means that even the time limit from the time the person contracts the virus can even be extended beyond 1 year if they don't know that the work caused the virus. So at a minimum, from the time they contract the virus, they have at least 1 year from that diagnosis, and it can be extended if depending on the time when they learn that the virus is work-related. We would say that the medical treatment is the first priority for an injured worker. We don't want to wait for the insurance company to provide treatment. As Scott mentioned in an earlier slide, it's also important to remember that not every claim is necessarily worth filing. For that reason, if you recover, there's no need to file a claim. People ask us, what's the best thing that we can do what's the best thing they can do for their case? And what we tell them is the best thing to do for your case is what's best for you. You don't wait, you go ahead and you get your treatment, and then we will file the claim for you if you believe that it's necessary. And once we are aware of the facts that it is work-related or may be work-related.
Can I just add to that? I think what we want to make it clear to everybody is that obviously if you can file a claim immediately and put everyone on notice, that's the best case scenario. But that's not always possible. The number one most important thing for everybody is to get better. This virus is very serious. It spreads very quickly. And if we're waiting 30 or 90 days for the insurance company to authorize treatment, it may be too late. So what we want to tell people is, look, if you don't file the claim immediately, it's okay. You have up to a year to do it. We will help you with it at a later time. Your first priority is take care of yourself and take care of the people that you're concerned about. And we want to make sure everyone feels a little bit comfortable that if you don't screw anything up by not filing a claim immediately.
Next slide, Jason. There are 5 benefits under workers' compensation. We talked about the most important benefit, which is medical treatment. And that medical treatment, besides getting better, can be lifetime future medical care. We don't know what the virus is going to do and what sort of future medical care a person's going to need 5 years, 10 years down the line. So the first benefit, as we discussed, is the most important benefit, which is the medical treatment. The next benefit is temporary total disability. Temporary total disability is the time that you're unable to work and a doctor determines whether or not you're temporarily totally disabled or temporarily partially disabled, which means that you have work restrictions indicating that you can't do your regular job. If you're temporarily totally disabled or temporarily partially disabled with work restrictions, and the employer indicates that they can't accommodate those work restrictions, you're entitled to temporary disability, which is 2/3 your average weekly wage, up to a maximum of $1,299.43 a week. Temporary disability and temporary partial disability is the same rate as state disability or EDD. So the only difference between state disability and temporary total disability through workers' compensation is that state disability is good for 1 year and temporary disability through workers' comp is good for a maximum of 104 weeks or 2 years within a 5-year period. The next benefit is the permanent disability, and this is where it's also important to have the doctor and have the injured worker communicate to the doctor about all the ailments that the injured worker is having due to the virus. We're learning more and more that the virus can cause organ damage. The virus can cause cognitive disabilities. The virus can also cause, other than just lung problems, they can also cause orthopedic problems. We have people who are having problems moving their legs now once they've been on a ventilator. Permanent disability is what's considered the compensation or settlement part of the workers' compensation claim. Permanent disability is calculated for the permanent impairment that you have for each body part. And it's at the end of the case once you've plateaued and been determined to be at maximum medical improvement. Maximum medical improvement is a term of art that we use where you may have good days or bad days, but you've basically plateaued. And then the doctor determines what is the level of disability you have for each body part, each organ that is now disabled, your lungs, your cognitive problems, anything that may be related to the virus that you've contracted due to work. Each body part, it has a value depending on the level of impairment, and the doctor determines what this value is. That value then goes into a formula with your age and your occupation, and those numbers are put into another formula, which gets very complicated but each level of case has a level of disability, a percentage of disability, and each percentage of disability has a value of a number of weeks that they would receive benefits at $290 a week for the permanent impairment they have. The question is how long and how many number of weeks will that person receive the $290? And that's again determined by the doctor to determine what your level of permanent impairment is that you have. The next benefit is the job retraining voucher. Of course, we want somebody who's injured to be able to get back to work, especially if they have a good union job with good union benefits. However, if you can't physically do your job anymore, the next benefit is the job retraining voucher. It's a $6,000 voucher that they pay a school for you to learn a new trade. The other benefit of this voucher is once you receive that voucher, you go online through the state of California and apply for another $5,000 cash to be used for job retraining or to be used however you wish. It does not need to be used just to learn a new skill. The final benefit is one that we don't like to talk about, but with this virus, it is becoming more and more prevalent. If you pass away due to the virus, your dependents, not your heirs, but your dependents, have a right to file a claim and receive workers' compensation benefits at the temporary total disability rate for a number of weeks, depending on how many dependents the decedent has. Dependents means somebody who relies upon the person who passed away for financial support at the time that they contract the virus. If you have one dependent, you would be entitled to, the dependent would be entitled to $250,000 payable at the temporary disability rate. If you have any more, it would increase up to $350,000 payable at the temporary disability rate to the people who are dependent upon the person who passes away due to the virus.
Can I just add a
Sure.
couple comments to that before we move on? Just wanted to mention that temporary total disability rates pay the exact same thing as state disability rates. The difference between the two is that temporary total disability may be payable for up to 104 weeks, which is 2 years, whereas California state disability is only payable for 52 weeks, which is 1 year. And then the only other comment I would add to that, Cheryl, would be that regarding permanent disability, it's based upon a book called the AMA Guides 5th edition. And based upon that book, a physician will make determinations as to a person's overall level of impairment. As Cheryl said, it's put into a formula, and that formula comes up with a percentage of disability. A person who is 1% disabled in California in 2020 would receive $870 at the rate of $290 per week. A person who is 99% disabled would receive the amount of $260,252, again at the rate of $290 per week. A person who is 100% disabled is entitled to their temporary total disability rate for the remainder of their life.
Next slide, Jason. The next issue is psychiatric injuries. We're finding more and more with the virus that these are valid and legitimate injuries that a person may have. The benefits for psychiatric injuries apply. You can get temporary disability if you suffer a psychiatric injury. You can get medical treatment if you suffer a psychiatric injury. And you can have permanent disability and the voucher if you suffer a psychiatric injury. All of the benefits under workers' compensation apply to this injury. What type of psychiatric injuries can a person have? It can start off where a person has a psychiatric injury because they're at work and they're afraid they're going to get the virus. Another type of psychiatric injury is somebody contracts the virus at work and they're afraid of their future health. They're afraid that they're not getting any better. They're afraid that they're going to give it to their loved ones at home. Another psychiatric injury is once they've recovered, they're afraid they're going to have that virus again or have reemergence of symptoms again, or maybe catch it again. Another psychiatric injury, which is one that I'm handling, which is one of the saddest cases I've heard, is a person contracted the virus at work, went home, she recovered from the virus, but however, she gave that virus to her husband and her husband passed away. Again, the documentation that we talked about in the prior screens is also important to show that she was the one that contracted the virus first and gave it to her husband. And I have no doubt in my mind that this injured worker is going to have future psychiatric problems and due to contracting the virus at work. Next slide.
So let's talk a little bit about the non-COVID-19 claims. These are questions that we get every day. And the questions I get from a lot of people are, if I'm a furloughed employee, can I still file a claim? And the answer to that is yes. A lot of the people that we deal with have been working for many years doing jobs. A lot of them work in pain, a lot of them work with problems, but many people continue to work because they have bills to pay, they have kids in school, they have the responsibilities that the rest of us have. So some of these people who've been working in pain or working with problems are now been furloughed. And a lot of them have approached me and said, is it too late for me to file a claim? I feel like I've had an ongoing claim for years. And the answer is no. If you're furloughed right now and you have some issues that you've been dealing with for a long time, you do have a right to file a claim. It is subject to the statute of limitations, which we could probably talk about that for an hour or so, but I'd say a good rule of thumb would be probably a year from the last time that you worked. But if you are furloughed, if you're not working, if you did have a claim that you didn't report, it's not too late to follow up on a workers' compensation claim at this time too. The other issue that I'm dealing with is, what about people who are working from home? Can you have a claim from working at home? The answer is yes. Again, if you've had a cumulative injury, an injury that's occurred over time, and you've originally started with this injury while working at the employer's work site, you've continued to work from home, and you've continued to cause that injurious exposure. So for example, maybe you have carpal tunnel. It started at work. You're working at home now on a home computer. The carpal tunnel continues to progress. Can you file that claim based upon the work that you've done at home? Yes, you have a right that is arising out of the employment in the course of the employment. Arising out of the employment in the course of employment doesn't necessarily mean it has to be at the employer's work site. I could give you another great story. I'm currently representing a woman right now. She works for a public entity in Los Angeles. Because of her age, they sent her home and said, we would like you to work from home. But they didn't send her home alone. They sent her home with about 6 or 7 boxes worth of materials for her to review. The boxes were stacked in her living room. And one morning she came out and she tripped over the boxes and unfortunately broke her wrist and broke a rib. That is a workers' compensation claim. That's an injury that occurred because of work. And that's a valid claim in my opinion. And again, when we talk about cumulative trauma claims, which are claims of problems that occurred over time, the fact that you're not at the employer's work site does not mean that you don't have a right to file a claim. And it does not mean that there's not injurious exposure outside of the actual employer's work site. The last thing I would want to bring up is what we call pre-pandemic claims. What if you had an injury previously and you haven't filed it? Just like the furloughed employees, just because you're not working doesn't mean that you do not have a right to pursue a legitimate workers' compensation claim at this time. I would suggest for anyone who has not filed the claim already to remember that you should probably do it within at least 1 year from the date of injury or 1 year from the date that you last worked. Did you want to add anything to that, Cheryl?
No, thank you. We can
Okay.
go to the next slide. The next slide is regarding a serious and willful misconduct of the employer. This is under California Labor Code Section 4553. When we teach at Trade Tech College, we go into about an hour to 2 hours of history of what workers' compensation was before it was actually workers' compensation. Before workers' compensation came into existence in 1913 under the Boynton Act, it was something the same as if you were in a car accident. It was a civil lawsuit. In 1913, when workers' compensation was put into the Constitution of California, it is a no-fault system. What that means is it doesn't matter if the employer is negligent or the injured worker is negligent. It doesn't matter who's at fault. It's a no-fault system. and the injured worker is entitled to benefits under workers' compensation. There's another claim besides the 5 benefits under workers' compensation if the employer is something akin to criminal negligence. We believe that the picture above on the slide basically shows exactly what a serious and willful misconduct is. It's when the employer knows and doesn't care that the injured worker is going to get injured. In this case, with COVID-19, they don't give the necessary precautions, even if there's rules under OSHA and regulations that they need to do in regards to social distancing, providing masks, wiping down the area, all of those things that are necessary as to providing a safe work environment. If the employer fails to provide the safe work environment something akin to criminally negligent, in other words, they don't care what their actions may cause, and they know it could even cause them to get the virus, we have to file a Labor Code Section 4553, serious and willful misconduct of the employer. The time limit to file a serious and willful misconduct of the employer is 1 year from the date of injury. This is a strict timeline, meaning it's a strict statute of limitations. We cannot get around it. So basically, once you are diagnosed with the virus, or even further, once we're saying that you were exposed to the virus and contracted the virus, you need to file the Labor Code Section 4553, serious and willful misconduct of the employer. What happens if a judge determines that the employer violated Labor Code Section 4553 and was quasi-criminally negligent? What that means is every benefit that we discussed before, that let's say the injured worker goes to the doctor and the doctor charges $100 and the insurance company or employer through their workers' compensation has to pay the doctor $100. And let's say that the doctor indicates that the injured worker cannot work and they're entitled to temporary disability at, let's say, $1,000 a week for their temporary disability benefit. That means the employer directly, they have no insurance for this. So the employer directly needs to pay the injured worker from their own pocket $50 of the $100 that they pay the doctor to go to for the injured worker to see the doctor for the appointment. They have to pay the injured worker $50. If the injured worker is entitled to temporary disability of $1,000 a week, that means that the employer has to pay the injured worker $500. It's a 50% increase of all the benefits provided under workers' compensation. We're not sure what the judges are going to decide in regards to the validity of a serious and willful misconduct, but it's important to be, 1, aware of the right to file one, and 2, of the time limit to file the serious and willful misconduct claim, and 3, to provide documentation to help prove that the employer was something akin to quasi-criminal negligence. Scott, did you want to add anything?
Yeah, let me just add to that. So as Cheryl said, workers' comp is a no-fault system. And people ask us this question almost every single day. I don't think my employer is looking out for my well-being. What do I do if I feel like my employer is not providing me a safe place to work? Well, even though it's a no-fault system, there's one provision under the Labor Code, which is Labor Code Section 4553, where we say that if the employer is so egregious in their behavior, it's beyond grossly negligent, if they just don't really provide me a safe workplace and they do this with sort of a wanton disregard for my safety, I can file this claim of misconduct under Labor Code Section 4553. And if it's found by a judge that the employer did engage in this type of misconduct, then it's a 50% penalty of all benefits paid payable to the injured worker. So it's the one point where we go sort of get out of the no-fault system of workers' compensation is this serious and willful misconduct. And we make a point in talking to you guys about it today because it's a very common issue. What happens if the employer has a work site? We know that people are sick at the work site. We know that there's not adequate protection. There's not masks. There's not hand sanitizer. is this employer engaging in serious and willful misconduct? Well, that's something that we will see, and we want you all to understand it and to inform your people about as well. Can we go to the next slide? So just to tell you a little bit about ourselves at Ford Wallach, we want to let you know that we are actually essential workers. Our office is organized by Teamsters 986, so everyone in our office is a union member, and people are working, and as you can see, we're trying to practice a safe work environment too, and that we're working in shifts, and we have people wearing their masks and doing everything they can, and we'd like to be available for everybody as a resource. If you need anything, you're more than welcome to call us. We've been participants in the labor community for a very long time, and we want to make sure we take care of our own people. Go to the next slide. And just again to follow up on that, like I said, we are a proud union shop. We are representing a lot of people with COVID-19 cases right now. We're happy to answer questions for people. Like we said, not everybody needs an attorney, and we're happy to basically talk to people to make them feel a little bit more comfortable about what's going on. And we'd love to be a resource for everyone. And thank you very much for this opportunity.
Can I add, what I'd like to tell people is if they have COVID-19 or any type of work-related injury, the member needs to make informed decisions. And that's what our job is to do, is to provide information so that you're making an informed decision so you can do what's best for you or the member.
Go to the next slide. So Cheryl and I have written a textbook. As I mentioned, we've been teaching at LA Trade Tech College for about the last 25 years. And when we teach workers' compensation, it's 16 hours over 2 Saturdays. We'd love to have you come. Armando Olivas, who started this off, is a frequent guest lecturer for us as well during our class. If you're interested in a copy of our textbook, we're happy to give you one. If you're a union leader and you need a little bit more information, please reach out to Jason Swanson in our office, and we'd be happy to move forward with that. Go to the next slide, Jason. So now I guess we open it up to questions, if there are any.
We got two, that I can see here, and folks feel free to send them in the chat if you got some remaining. But one of them was, as you know, the healthcare workers have been at the forefront of a lot of the work being done. And so one of the questions we got from Kenya Rivera was, how does this apply to nurses who are not provided with the proper PPE?
You want me to answer that, Scott, or go ahead?
Yeah, sure, go ahead.
Well, I would say that if they catch the virus, or if they're afraid and they have a psychiatric injury, they may have a claim. I mean, it's an open-ended question, but if they catch the virus, they're entitled to all those benefits. The Labor Code Section 4553 serious and willful misconduct claim is also a valid claim that we would want to consider, depending on the facts, whether or not we should file that, because of the nature of their job, they need to be provided with the adequate protection.
And I would add to that, first of all, I would immediately argue that anybody working during the time of the shutdown has proven that they're at an increased risk than the general public, and that they've met their burden that arose out of employment in the course of employment. If this occurred actually from March 19th to present, that person is covered under Gavin Newsom's executive order, which means that there is a rebuttable presumption in her favor that this is a work-related injury. So on both of those counts, I would say clearly it's a work comp case. The next part of your question was, what if they weren't provided PPEs? Well, that's a big issue. That may rise to the level of a serious and willful misconduct complaint. I don't know, I'd need to know more facts about that. But again, why did they not get the PPEs? Was it because they weren't available? Was it because that, we don't know. But those would be issues that would go into a determination as to whether or not there was a serious and willful misconduct complaint. But I think clearly if that person contracted the virus, they have a right to pursue workers' compensation benefits.
Copy. Thank you. We got a series of questions from Charles. There's 5 questions. So I'll ask some of them, Charles, but I would email Jason. I think there's some of them are going to the more individualized. Does the employer bear any liability for not checking temperatures of essential workers coming to work?
Well, let me just answer that and say, we're limiting our presentation to the laws of the workers' compensation in the state of California. So regarding workers' compensation, the answer would be no. There's other avenues we may want to look at. Is there going to be civil liability? Also, is there an issue under your union contract? Under the workers' comp claim, no, it's a no-fault system. I don't think that would rise to the level of a serious and willful misconduct complaint, but you may have additional remedies. Most union leaders should know their contracts pretty well and would probably be the expert in that area. Most unions are represented by competent labor counsel who can probably interpret the contracts as well too. But the straight answer is under the workers' compensation system, no.
And then one of them was, Deborah, I would email your question to Jason because there might be some more nuances there that to protect privacy. If an injured worker uses, this is a separate one. If an injured worker uses their own insurance till the claim is approved, does the employer have to reimburse the injured worker any out-of-pocket cost?
I would argue yes. I would argue that yes, they would. And also the insurance carrier most likely will file a lien in workers' compensation to be reimbursed by the workers' compensation insurance company or employer if they're self-insured. That means that the workers' compensation benefits would have to reimburse the private health insurance.
There's always an argument in workers' compensation that if the employer fails to provide medical treatment and the injured worker has to self-procure medical treatment, that is reimbursable.
Thank you so much. And so with that, please continue sending your questions to Jason at jswanson@fordwallach.com. Cheryl and Scott, this has been tremendously helpful. We were asked via email and through the presentation in the chat if this would be available. Lots of folks have lots of interest to continue learning more. And so again, as Cheryl and Scott mentioned, please, if you need their book, feel free to reach out. They have the whole book on their authors, lawyers, and most of all, friends of labor and organized labor. And so we really appreciate you all taking the time.
It's our pleasure, and thank you very much. And Cheryl and I have been teaching at Trade Tech for a long time. What we've learned is, as much as we want to answer everyone's questions, we also want to protect your privacy as well. So thank you for the opportunity today. It's a privilege.
Thank you all so much. And again, for everyone, this will be up immediately available on Facebook, on the Facebook link. If you want to share the link on your own personal Facebook pages to your members, members you have online, feel free to share the link. It's going to be immediately available. We will also have it up on lcs-la.org, where we have a series of webinars we've done on different subjects that we've covered. And feel free, if there's other topics you all want to be covered, feel free to email us, Scarlett or Hugo at the LA Fed. I'll put my email address in the chat box that you want to cover for future topics. And you have Ford Wallach's email address for any questions to them. But we appreciate you all tuning in. Again, the video will be available immediately on Facebook, and it will also be uploaded via YouTube, along with any other relevant material. Thank you all so much.
Thank you, guys. Be safe.
Thank you.